Welcome everybody. Thanks for joining us for our keynote event here. Our keynote lecture by Judge Chile Eboe Osuji. Speaking again today. We appreciate your time and generosity, and it's a real honor to have you here. The talk is the Right to Peace Initiative, and Richard Amesbury, the Director of Shippers, will be introducing Judge Eboe Osuji. Before that, Megan Reed of the Zorian Institute, who brought our keynote speaker here, is going to say a few words about the Zorian Institute. Here you go, Megan.
Thank you so much, Tim. And I'm sorry if this is repetition for anyone who is upstairs this afternoon, but I am going to share a little bit about the Institute. First, I'd like to thank Genocide Awareness Week and the organizers of this week, especially Tim, who has worked alongside us every step of the way to make it here. So thank you very much to GAW. And everyone here at ASU who has put this all together. Really appreciate it. The Zorian Institute is a nonprofit organization that is dedicated to raising awareness on issues of genocide, human rights, and diaspora homeland relations through scholarship and education. So I'm going to share a little bit about our programming and educational programming that we do. One of our main programs is a 2-week intensive graduate level Genocide and Human Rights University program hosted in partnership with the University of Toronto. We bring 20 students every summer to Toronto to learn from leading experts in the field, and they really get a foundational understanding of genocide studies. They learn case studies, themes, they live together, they learn from renowned experts, and it really has built a community of genocide scholars. More information on that can be found on our website, and if you're interested or know someone who may be interested in attending that course this coming summer or in future years, feel free to find me after today's keynote speech. We also host 2 peer-reviewed academic journals. Genocide Studies International is probably going to be the journal that interests most of you here today. We do have 2 editors. I'm not sure if they're in the room. I don't see them yet. 2 editors of the journal here at Genocide Awareness Week, Dr. Alex Alvarez and Dr. Henry Theriault. So if you have any questions about submitting to the journal or the journal in general, you're welcome to find one of them or myself, and we can give you more information about that as well. We also host a number of conferences, lectures, symposia. We get involved with weeks like this, for which we're so grateful. We also host a few podcasts. So those are available on all of our streaming platforms and on our website as well. So we encourage you to check that out. Upstairs this week, we have an exhibit. It's called Women in Genocide from Persecution to Empowerment. So it's on the 4th floor, part of Genocide Awareness Week this week. We encourage you to check it out. The Zorian Institute put it on in partnership with the Armenian Genocide Institute Museum. And it's a comparative analysis review of 3 different cases of genocide. So we have the Armenian genocide, the Holocaust, and the Rwandan genocide. So we encourage you to check that out. That's upstairs on the 4th floor. Thank you so much. I'll now pass it over for the introduction of our keynote speaker today. Thank you.
Thank you, Megan. And thank you very much to the Zorian Institute and to the Rosenbluth Family Charitable Trust for making the events of this week possible. My name is Richard Amesbury. I'm the director of ASU's School of Historical, Philosophical, and Religious Studies, and I'm very pleased to welcome you to this afternoon's keynote address. Before we get started, I'd like to acknowledge 2 people who really put in the work to make this week's events possible. Tim Langell, will you stand and be recognized, please? Okay. So it's my honor to be able to introduce this afternoon's keynote speaker, Judge Chile Eboe Osuji. So Judge Eboe Osuji was the 4th president of the International Criminal Court in The Hague from 2018 to 2021, and is the distinguished international jurist at the Lincoln Alexander School of Law at the Toronto Metropolitan University. From 2012 to 2021, he served as a judge at the ICC, first as a trial judge and eventually as an appellate judge. Prior to joining the ICC, Dr. Eboe Osuji served as the legal advisor to the United Nations High Commissioner for Human Rights in Geneva. Earlier in his career, he worked at the International Criminal Tribunal for Rwanda and at the Special Court for Sierra Leone as a senior prosecution counsel. Before joining the International Public Service, he practiced law as a barrister in Canada, his adoptive country, and Nigeria, his birth country. Following the end of his tenure at the ICC, he has served in the following visiting professorships. The Paul Martin Senior Professor of Political Science, International Relations and Law at the University of Windsor, Visiting Professor of Law at the University of California, Los Angeles, the Herman Flegger Visiting Professor of Law at Stanford University Law School, Distinguished Visitor at the University of Toronto Faculty of Law, and a Senior Fellow at the Carr Center of the Harvard Kennedy School. He has also taught as adjunct lecturer at the Faculty of Law of the University of Ottawa. He received his PhD from the University of Amsterdam, his LLM degree from McGill University, and his LLB degree from the University of Calabar. His honors include the Goler T. Butcher Medal of the American Society of International Law, Doctor of Law degree, honoris causa from McGill University, a Doctor of the University degree, honoris causa from the University of Middlesex, the Gold Medal of the Honorary Patronage of the Philosophical Society of Trinity College Dublin, and the Chief Emeka Anyukwu Lifetime Achievement Award. He's a member of the high-level panel on media freedom and a senior peace fellow of the Public International Law and Policy Group. He has an extensive record of legal scholarship, including the books End of Immunity, Holding World Leaders Accountable for Aggression, Genocide, War Crimes, and Crimes Against Humanity, 2024, International Law and Sexual Violence in Armed Conflicts, 2013, and Protecting Humanity, 2010. Just this past week, Judge Eboe Osuji was selected to join the Caribbean Court of Justice as a judge. So we're very honored to welcome you today, and the topic is the Right to Peace Initiative. Please join me in welcoming Judge Eboe Osuji.
Thank you very much, Professor Amesbury, for that kind introduction. And again, thank you all for coming. I thank the organizers of the conference, Professor Langille, I say the French word. He says I can say it anyhow. But thank you very much for putting together this show, and for Crowther as well. I have to join the gratitudes to the Zorian Institute for bringing me here. Craig Sarkisian is sitting there, brainchild of the Institute, and Megan Reed. Thanks a lot. Now, this evening I'm going to speak about the right to peace as a new direction unexplored in international law. The question came up, what else can be done to make international law effective in protecting humanity? As I said earlier in the book talk, when you plot the development of international, I'm repeating myself here, but for the benefit of those who were in the room, when you plot the development of international law, you find that its progression had been spurred the most or most often by armed conflict, wars. In 1648, we had the Peace of Westphalia at the end of an exhausting 80-year war or 30-year war in Europe. People stopped fighting, all right, let's start organizing ourselves. So you had the Treaty of Osnabrück that contains elements of what we recognize today as international, or the idea that it is not up to an overarching Holy Roman Empire to regulate external relations of the various principalities and kingdoms and duchies within the Holy Roman Empire. It wasn't up to Rome to do that, so each of those principalities had jurisdiction to regulate their affairs internally, including rights to religious minorities within the Holy Roman Empire. You had in that agreement, that treaty, elements of what you might actually call free trade agreement. That's one of the unspoken elements of the Peace of Westphalia. In it, you also have elements of the idea of resolving dispute using judicial methods, courts of judicial processes to resolve dispute. All these you find in the Peace of Westphalia or the Treaties of Westphalia. We can fast forward to 1919. There are other things we can talk about before 1919. But in 1919, at the end of the First World War, we saw a big development. It's something that hadn't happened before in international relations. The idea of creating a multilateral organization that will modulate peace, that will be a clearinghouse for actions of the international community to contain threats to international peace and security, the League of Nations. That was revolutionary. Before that, we take the UN today for granted. We beat up on the UN for its failings and weaknesses and politicization. But before 1919, there was no organization like that. Again, resulted from at the end of an armed conflict. Similarly, 1945, I'm now hopping and skipping. I could talk about other developments in between. We could talk about the American Civil War that gave us the Lieber Code in 1863. Before that, there was no codification of rules of international humanitarian law until Francis Lieber helped Lincoln formulate that kind of code. Although it was a code formulated to regulate the behavior of American soldiers fighting the Civil War, but that was a template that later on inspired the Hague Peace Conference of 1899, as well as the Hague Peace Conference of 1907, in terms of the Code of International Humanitarian Law. That was an armed conflict that spurred that development. 1945, again, at the end of the Second World War, we had ourselves, again, the United Nations. We had the idea of a real international tribunal that tried atrocities, war crimes committed. We had the Convention Against Genocide, adopted because of what happened, the genocide that was committed in the course of that war. So we can trace different development stages of international law, and we will find wars behind that. Now we are in that stage again. Wars going on in Ukraine, in Middle East, Gaza, continuing one, in the DRC, in Sudan, and elsewhere. And politics around that coalesce to ask us, is this the end of good behavior in the international order as we know it? And I say, no, it isn't. There's reason for that concern, understandable reason for that concern. But I do think that when we all emerge from it, we will have greater appreciation of good behavior in the international order. But we would also ask ourselves, what else can we do to enhance the protection of humanity when this source of madness erupts again in future? Now, I'm going to this evening concentrate on war of aggression and what can be done about it. By the way, that's another development that occurred at the end of the Second World War. Wars of aggression were received the imperative of accountability that had been missing all along. Before 1919, definitely, it was free for all for any state that felt strong enough to invade another state. There was no international law that said, thou shalt not commit the crime of aggression. There was no international law. The international law went only as far as say, well, if you're going to do aggression, there are just some things you cannot do when the war, when you're fighting the war. But you can invade. After all, that was why European empires colonized much of the world. It was aggression that they used to do that. Go to a place occupied, run over the place occupied. So the shift in the wars of aggression began around 1990. There was an effort, for instance, in the Paris Peace Conference to prosecute the Kaiser for the crime of aggression, but it did not work because the jurists gathered then knew that, hang on, before the Kaiser, before the Germans started the First World War in August 1914, there was no law that said they couldn't do that. So the principle of the rule of international, the rule of law that says you cannot retroactively impose a criminal norm. So the rule of legality. So those jurists gathered in Paris knew, well, we can't really, in good conscience, prosecute the Kaiser for invading Belgium, Luxembourg, and starting the First World War. But what we can do is hold him and Germans accountable for violations of laws of war in the course of that armed conflict. So that they did. But what it did recommend, even as they said, no, we're not going to prosecute or set up an international tribunal to prosecute the crime of aggression. What it did say, there is no law against that, but what we do recommend now is from now on, it is desirable for the law, international law, to develop in a way that prescribes the wars of aggression. So that movement, or that impetus, started in 1919 at the end of the First World War, but it concretized in 1945 at the end of the Second World War. The tribunal, the Nuremberg Charter, explicitly gave the tribunal jurisdiction to prosecute the violations of international peace, or basically the wars of aggression. And the leaders of the Third Reich were prosecuted for that. And the Tokyo Tribunal as well, the leadership of the Japanese imperial government was also prosecuted. Surviving leadership, some of them had committed suicide, as did Hitler in Germany. But the members of the Japanese Imperial War Cabinet were also prosecuted for war of aggression. The only person that was spared prosecution was the Emperor of Japan, because the US wanted to be able to occupy Japan and rule it without embarrassing the population who regarded the emperor as a god. So he was spared prosecution, but the rest of his government were prosecuted. So that was the beginning of proscription of the war of aggression. Now, there's more that can be done there. In 1998, the Rome Statute was adopted, and war of aggression also made a crime under the Rome Statute. But the definition or the circumstances under which the ICC can prosecute wars of aggression perhaps require some adjustment. Why? The wars of aggression are defined in the Rome Statute as something that only the leadership of a country can be held accountable for. You can prosecute those who are in a position to direct the military or the political direction of the country in question. You cannot prosecute the foot soldier for the crime of aggression. You can't. You cannot prosecute a middle-ranked officer, military officer, for a crime of aggression. You can only prosecute the leadership of the state, military or political leadership, for a crime of aggression. But that kind of limitation you don't find for the other three international crimes. There are 4 international crimes, core international crimes: aggression, genocide, crimes against humanity, war crimes. So for the other 3, except aggression, you do not have limitation against prosecuting foot soldiers, right? You only have it for the crime of aggression. You could see how that's how the interest of leadership of a state. They want to be able to direct the soldiers to fight wars of aggression without giving the soldiers the right, the objection, the conscientious objector privilege. For the other crimes, genocide, war crimes, crimes against humanity, the ordinary soldier does not have the excuse for carrying out an order. The ordinary soldier is told, well, you have the right to resist an illegal order. You can say, no, I will not carry out an order that is manifestly illegal. Order to commit genocide is manifestly illegal. Order to commit war crime is manifestly illegal. Order to commit crimes against humanity would be manifestly illegal. But for the crime of aggression, no, don't worry about that. You don't need to object saying, well, it is manifestly illegal to direct me to invade another country. And that is a limitation that needs to be worked on, because without the foot soldier, you can't really effectuate a war of aggression. They are the ones who make it happen. But it is by holding them also accountable, giving them that right to say to their commander, sorry, if you want to invade that country, that I don't see a reason for you to. They've not attacked us. It's an innocent country minding their business. They may seek associations as they please. You don't like what they're doing. You want me to invade them. That is manifestly illegal. I'm not going to do it. So that is a kind of enabling that the foot soldiers need to have, by making them also accountable, so that they're able to tell their leaders, so I'm not gonna go with you in that invasion expedition. So that is one adjustment that can be made: enlarge the scope of accountability for wars of aggression, so as to make ordinary soldiers also accountable for wars of aggression. That is not yet there, but that is, in my view, one adjustment that can be made. But that is on the criminal side of adjustment of international law for the future. Well, the war in Ukraine makes that point, it creates the need for that kind of adjustment, but we can put that to the side. Another adjustment that can be made that does not involve criminal law is the adjustment in the direction of the right to peace. That has got nothing to do now with criminal law. It is about empowering national legal systems to enforce the norm against crimes like crimes of aggression, in the sense of, if you recognized peace as a basic right, and as we speak, we all take peace for granted in every international document, more or less, you tend to see references to peace in terms of presumptions of what the system is all about, what the international system is all about, what the good order and international system is all about. Peace referred to all the time. You get the sense that peace, in that sense, becomes the oxygen we breathe. We take it for granted until it is no longer there. So that is similar thing with peace in international instruments, international meetings. Peace, peace, peace. And you said, okay, all these references to peace, what does it do for us in real terms? We have, at the end of the Second World War, another development international human rights law. We have a Bill of Human Rights, quite lengthy, the right to security of the person, freedom of speech, freedom of religion, and so on and so forth, freedom of association, freedom of movement. You ask yourself, which one of these freedoms can you meaningfully enjoy in circumstances of ruptured peace? Your freedom of religion, your freedom of movement, your freedom of speech. You find that there's seldom a right, human right, that you can enjoy without peace. And if that is the case, you said, should it not be the case that peace should be the most basic of all freedom, since it is on it that all the other rights rest for their meaningful enjoyment? But that is not how it is in international law. There is no enforceable right to peace. There's an assumption that peace is a good thing, but it doesn't have the quality of being enforced in a court of law. You cannot go and sue somebody who invaded your country, disrupted your life. Look at Ukrainians, for instance. Lives of people upended in very dramatic ways. But they can't do anything about the fact that their peaceful enjoyment of livelihoods has been upended in such violent way. And that is where, in my view, the next adjustment needs to happen. There's a need, given the value of peace to all the other freedoms and rights, there's a need to recognize peace as a basic human right. Not just make statements about it, but concretely put it in an international instrument, international treaty that says, yes, every person, every nation, every individual, every corporation, business should have the right to peace. But beyond that, it's not enough to declare the right to peace. There needs to be consequence for violation of the right to peace. What happens then if there's a violation of the right to peace? Your business is destroyed, your home destroyed, your employment blown up. What happens then? That is where the consequence part of it comes in. There should be the possibility within that treaty that's being talking about, of giving states the jurisdiction over inquiring into whether there had been a violation of the right to peace. If yes, then reparation ordered by the national court. It can be any court, but definitely national court. You can do it for an international human rights tribunal, an international court that may be established by that treaty. But before all of that, it is important to give each member state to that treaty the right to establish its jurisdiction over that inquiry, whether somebody's right to peace or a corporation's right to peace has been violated. If it has been violated, then the national court will make the necessary order, make the necessary judgment, impose the necessary reparation, which can be enforced in the various national jurisdictions of member states of that treaty. So that is one way of making wars of aggression unprofitable for those who embark upon them, as well as holding accountable other entities like businesses who are complicit in it. Complicity in the crime of aggression, in that sense, in the sense of violation of the right to peace, need not entail from the start telling a weapons manufacturing company that you cannot manufacture weapons or you cannot sell weapons to a state, because in the wild, wild west, which international order can be, states are entitled to protect themselves. And there's nothing wrong with somebody establishing a company that manufactures weapons for purposes of self-defense of a state that needs self-defense. You cannot hold that corporation responsible for violation of the right to peace. Why the problem is if you sold weapons to a state that said, I need to buy weapons from you because I want to be able to protect myself from the guy next door who had violent tendencies. But it turns out that the state you sold the weapons to uses your weapons to invade another country who had not threatened them, for which there is no claim of self-defense. It becomes problematic if you keep replenishing the stock, the arsenal of that state that is invading another state, so they can keep doing it. At that stage, excuse me, I'm trying to kick a cold here. At that stage, it becomes problematic because we now have a question of complicity in the crime of aggression, because it's no longer supplying weapons to a state that needs to defend itself. It is now continuous supplying of weapons to a state that is in the course of invading another state. So that is in that sense that you can have corporations held liable for aiding, abetting crimes of aggression. So in that sense, we cannot say that the crime of aggression, the right to peace, is something that should ensnare all businesses engaged in arms trade or weapons manufacturing. So these will be some ways of enhancing international law in the future and making international law making wars of aggression less profitable for those who may engage in them. So in a nutshell, those are the outlines of the Right to Peace project. I could keep going on and on about it, including mentioning that we can also have in that treaty a removal of the right to claim immunity on the part of those who may engage in wars of aggression. Now, you have noticed that in talking about it, I've limited myself to the crime of aggression, the wars of aggression. Some people may say, what about war crimes, those who engage in war crimes? What about those who commit genocide and all that? I limit myself to wars of aggression because they are, of all the other crimes, the crime that is least likely to generate controversy that may detain everybody. The project of right to peace, by the way, have been tried at the United Nations Human Rights Council. What I'm saying here is not a very original idea. I'm just trying to narrow it down. It had been raised at the UN Human Rights Council, but it never went anywhere. Why? Because whenever you raise it, the right to peace, everyone's, yeah, that's a very good idea. But we want to add this to it. We want to add that to it. We want to add the freedom from discrimination has to be part of right to peace, freedom, gender equality, racial discrimination. We have to, because when there's discrimination, there is no peace without justice. So all that we need to put in the project of right to peace. But what happens is once you expand it that way, people basically, you chill a lot of folks who might have an initial interest in it. They'll turn around, well, if I'm going to add discrimination in here, I can see myself being hauled before an international court, because in our country there are discriminations between ethnic groups or racial groups or genders and all that. So sorry, I'm not going to go there. So it is in fact for that reason that it's important for us to narrow the scope, to at least to begin with, limit it to the crime of aggression. It is easy to appreciate that it is, less amenable to debate whether you invaded another country than, well, do you have intent to destroy a group in whole or in part? What is the evidence of that? So it is for that reason that I would say we'll limit the right to peace to wars of aggression for now and see where we go from there. I'm going to leave it there and take any questions you may have. Thank you very much.
Well, thank you for that keynote and sharing your expertise and your Right to Peace initiative with us. We open up the floor for questions. See a couple here, and also online. If you're on Zoom and you've got some questions, please drop it in the chat, and I will. Greg Sarkeesian gets the first question, the director of the Zorian Institute. You get the mic.
I think I heard you said that right for peace should be in national laws. If we have a country where there is no, if the country is not signatory of certain international law, for example, Convention on Genocide, if USA is not signatory of that law, we cannot prosecute USA or take them to the international court. How do you see countries adopting right for peace as a national law? I mean, this is a challenge that it's mind-boggling for me. That's my question.
Thank you. In international law, there's something we call the domestication of a treaty. It means you adopt a treaty at the international level. It can still do its work at the international level. For instance, take the example of the Rome Statute. The ICC, the Rome Statute, or the norms of the Rome Statute are configured to work at both what we call the vertical level and horizontal level. Horizontal is domestication when you bring it to level of states. In each state will now internalize it, make it part of their national law. Okay, but that is not, it doesn't detract from the fact that you have an international court that operates at the international level. ICC can prosecute cases that fall within its jurisdiction, but in a place like Canada, where we have what we call the crimes against humanity, genocide and crimes against humanity War Crimes and Crimes Against Humanity Act specifically indicated that we are doing this in Canada in order to implement the norms of the Rome Statute. So we are putting the norms of the Rome Statute within the Canadian Criminal Code, so that if the ICC, because the ICC cannot prosecute every crime, and so you have a second level of that, what you might actually call the primary level of prosecution, which is in the national system. So you do the prosecution there as well for those who are not prosecuted in the Rome Statute at the ICC. So that is domestication. Australia has done that. England has done that. France has done that. Canada has done that. You can do the same thing with this treaty I'm talking about. Geneva Conventions, by the way, have also been domesticated by many states. So you have the Geneva Conventions of 1949, but in many countries, you encounter what you call the Geneva Conventions Act or Geneva Conventions law, which now would make the norms of Geneva Convention part of the domestic order of that state. That's why countries like Germany, France are able also to prosecute people in that country for committing war crimes abroad. So you do the same thing here. Now, one value of domesticating international norms in that way is that where you have the most teeth to law is in national systems. One of the weaknesses of international law is that at that international level, it does not have self-enforcing ability. International law does not enforce itself at an international level. You depend on states to enforce international law. And the most effective way to do that is if you brought down those international norms within the national order, then they become very effective. It becomes now a matter of the state concerned and whoever it is they're going after. You're not just going to be ICC out there. It becomes a matter for state. So it is a very, very effective way of doing it. Now, will all states domesticate the norm at the same time? No, we're not going to have that happen uniformly, at least at first. You mentioned the United States and the Rome Statute. Keep in mind here, when we hear US hasn't ratified the Rome Statute, everyone think, well, why is the US doing this? The US not like international criminal law? It's not that simple. The US has not ratified a lot of treaties, including, believe it or not, the right to child. Was it? Pardon me?
ICC, the optional protocol.
Yes.
ICCPR,
Yeah. Exactly. The Children's Rights Convention as well. I think the US is the only state that has not ratified it in all of the world. Okay. So the ICCPR, even the Law of the Sea Convention. So there's a lot of treaties the US has not ratified, but that failure has not stopped the international law relating to those treaties operating reasonably well. The US took 40 years to ratify the Convention Against Genocide. Adopted in 1948, the US only ratified it in 1988, after Senator Proxima harassed his colleagues consistently many years. So it is important for states to start a project, states who see the value of a certain project to start it, get it going. Hopefully with time, others who've not seen the value of joining may see the value of joining. A government of one state that doesn't like any aspect of international law can change with a new leadership, and then finally they join. So it is important to get going with the Right to Peace project and hopefully others will join.
I have a question beyond the formalism of law, beyond the authority that we give it, and beyond the intimidating effect it has on us, legal scholars, laypersons, and more. Here is a cheeky question. As a law student back then, I read about the critical legal theorists, and I was really enthralled by the idea that they put forward in terms of what judges do. And you've presided many adjudicating panels out there in many courts. The critical legal theorists say that decisions are actually already made when we are faced with different situations. And earlier we spoke about how legal decisions are soiled or are corrupted rather with politics, with religion, and much more. My question to you is very simply, how many times do you think you've been faced with that sort of situation? Or how many times have you seen that happen around you where people already made decisions based on politics, emotions, and more, and then backtracked and made it look legally sound and very intelligent, just to convince us that that was the process of reasoning that happened in the course of handing down a decision?
As you say, that's a cheeky question, isn't it? Let me put it this way. I faced that question in some instances, in circumstances less cheeky. But I tell people, you do not go to, I speak for myself now, as a judge, you do not go to the court with a completely blank mind. There's a reason why they say for us to have a bench that serves the community, that bench of judges need to be representative of that community. There's a valid basis for that. It's easy to see something that comes from your experience before somebody who hasn't had that experience sees it. It'll be easier for you to catch some spurious arguments people may make, trying to pull wool over your eyes. And that is the social, ethnographical level. At a professional level, a judge should also be prepared. I tell myself, once you walk into the courtroom, you've researched the papers, you've read the papers, you've studied the case. You've seen lawyers' submissions written, submissions, but you've not heard oral arguments of those lawyers. But you have to go to court. You should be prepared to make a ruling on the spot if you're called upon to rule right now, right here. What you cannot do is stop there. Say, yes, I have an idea of where the justice in this case should be, right? So I listen to nothing said. But what happens is when you go in armed with certain background, certain knowledge, it becomes easier for you to probe the limits of certain submissions that lawyers may make before you. You're able to engage them in conversation, but you must have an open mind still. So that is what I can say. I don't know of any judge who said, well, I have formed the impression of what this case should be, end of story. That's not been my experience, and that has not been, I've not seen that from anybody. If that is the case, they wouldn't tell you, they haven't told me. But what I do see is that I have seen people who would from my experience with colleagues, can say this. In discussing the case, we formed certain views of how this case might fall. But then we go to court and we listen to submissions of lawyers. People come out and they change their minds. And in my view, there's some, it's healthy approach to doing the work.
Professor, could you clarify something for me? Did you say that if a state sells weapons to another state, which then uses those weapons to do something illegal, then the first state should be held accountable? Is that what you said?
Sorry, come again?
I thought I heard you say if a state sells weapon to another state, and that second state uses those weapons to do something illegal with them, should the first state who sold the weapons be held accountable also?
Not automatically. That's not what I said. I said, I did not say states, by the way, just to be accurate. I used companies in my discussion, example of companies, but we can talk about states as well. The point is not, for instance, where state A buys weapons from state B, and state A uses the weapon to invade state C. I don't see automatic liability for state B who supply the weapons. What I see raising questions of accountability for state B is if, for instance, state B supply the weapons to state A say, I'm coming to you, state B, to buy weapons because I need to defend myself against state D. And you sell weapons to state A, and state A turns around and invades state C with weapons, and you, state B, keeps supplying the weapons used to invade state B. I do see questions of accountability there, because at the point the invasion has happened, right, you should know that this is now a war of aggression, and you should not be enabling it by replenishing the stock that continues to make that happen. For wars of invasion, I mean, okay? Does that answer your question?
Yeah, thank you.
First of all, Judge, thank you for coming here today. My question is this: the legitimacy of organizations like the ICC and the UN is derived from the power which member nations give to it. Given today's trends of isolationism, growing authoritarianism, and retreat from international cooperation, what is the role that these organizations will play in the future?
These organizations still have a role to play in the future. As I said earlier, in the other room, as bleak as the times seem, our own time seem, I'm optimistic that we will get through it. It will be difficult, but we will get through it. The ICC, for instance, was an example of how state institutions can insist on doing their work. Every time the ICC has faced quote unquote sanctions prospect, the judges of the court knew that there is somebody who wouldn't like what we're going to do here. That somebody may already have told us, you do this thing, we're not going to be happy with you. We make life very, very difficult with you. We will impose sanctions, we prosecute judges for authorizing certain investigations. Sometimes those signals are explicitly sent to the court before it would do its work. But the courts, the ICC judges would nevertheless say, yes, we had all those threats, but this is a decision we are going to render, we render it. When I was at the court, we had the first spate of sanctions against the court and threats, more sanctions against the chief prosecutor, and threats of prosecution of judges and sanctioning them. And in a town hall I would have with judges and staff once every 6 months, we will gather in a big hall here where we'll share, how are we doing? What are the issues confronting us? It wasn't because of the sanctions and all that. It was something we were doing before. But it so happens in one of those sessions, the question was always on everybody's mind, what's going to happen to the court and the staff? And I said, look, that's the wrong question. That's the wrong anxiety. If you are working in this institution and you're worried about your travel privileges to the United States, I was a friend at the time, or sanctions against your economic circumstances, then ask yourself whether you are in the wrong place, working in the wrong institution, because this court was established to insist on accountability for genocide, crimes against humanity, war crimes, and the crime of aggression. And human beings, lots of human beings die when those crimes are committed. So we are betraying the memories of the victims of genocides of this world, Holocaust, genocide in Rwanda, and other places. If we are here, as staff and judges of the court, worrying about, well, we're going to be able to travel to certain countries, is our bank account going to be frozen by somebody and all that? You're asking yourself that question. Have you stopped to ask, what about the people who die in these contacts? So this is part of what these institutions think about when they do their work. And I do believe that they continue to have relevance for the future. Thank you. There's a question over there.
Thanks very much for the talk. My question actually follows up on the previous question, and so maybe you've already answered it in part. But the question is this: in a moment, there was a golden period for the international law following the Second World War, and perhaps that period is coming to a close, or at least is encountering new sorts of challenges in the rapid transformation system. But it seems to me that there's an important question about what what is the sort of purpose that asserts it, whether or not that is taken up, or that opens it up to the possibility of cynical implementation, in which, for example, invasions take place in the name of self-defense, in the name of peace. And it seems to me that one of the things that is notable about the last couple of decades is that there was a sense in which the tacit idea of the right to peace underwent imperative reforms that promised a kind of end to war, right? This sort of vision of a short-lived vision, perhaps, a vision of the post-Cold War integrated global economy. And that was about deterrence, not about the fundamental. So I wonder if you could just comment on what you see as the meaning of the project, international law, in a moment in which the international law has the potential to have a kind of growing impotence in its capacity for deterrence and enforcement. Is that the right project? And if so, why?
Very profound question indeed, but I'm not sure that it's always either or. I believe we can walk and chew gum at the same time. We can grow a norm that gives certain value to humanity, right? Protection of humanity, because it's the right thing to do. some value to it. We can also grow that norm if some of the always deterrence, by the way, as you know, is a byproduct of norm. People rarely get into law formulation because we want to. The first thing on our mind is deterrence. Yes, it is there, but there's other values that can precede the value of deterrence. Nevertheless, I don't think that the crafting of a norm for its own value is inconsistent with the norm having some deterrent effect, right, on certain conduct. I know you're looking, we can fine tune that answer, but I do believe that we can deterrence into what we're doing. So what I'm proposing should happen part of giving peace its own value as a fundamental norm that one can consider as a substratum to all the other norms, because peace is that important, because peace permeates everything people think about the international order. Peace permeates what we conceive as a community within the national order itself. Thomas Hobbes talks about, the state of nature, why we have to give that authority to a Leviathan so it can protect everyone. The whole point is to have a community in which it's not every man, every woman for himself, but one in which there is peaceful coexistence amongst members of that community so that it can form one. And I do believe that it has value, but then to have consequences for violation of that norm, of that order, it's not something we can also reject as value. So it can have a secondary value. So, thanks.
Thank you so much. They're gonna sound like I'm not looking for anything. Throw something at you that's hard to
Go ahead, throw away.
try to understand how to support. We start to this idea of right really goes beyond being a right. It seems like a cultural value, ethical value, deep in something. And that's exciting. But I have two questions. They contradict each other actually, but I'll ask them both. The first is we've talked about the law being sort of corrupted by politics and economics and so forth. But law itself, I would be hard pressed to find a system of law that has been formed through economic, political, and other interests. Sometimes in a positive direction, sometimes ethical grounding, and sometimes not so. And so when we're generating new law, one question is how do we get this concept that you have into a real legal, a legal language that really is something reflective of the vision that you have. So that's the first problem. And think of the Genocide Awareness is a great example where that was a political compromise, nasty backroom politics, all that kind of stuff. Something good came out of it, but there's a lot of limitations to that as well. And then the second question is, okay, so you're adding another right to the many rights that we already have. But we have been really bad at enforcing the rights that we already have, right? So we have a right to bodily integrity, but sexual violence is prevalent now as it ever was. We have other rights like this. Is there some vision that you have that the right, that defining this new right would actually enable better, I'm not even going to say enforcement, but better grounding of this in the legal system and political system?
Yeah, I thought you were going to ask very difficult questions. They are difficult. You made it seem as if you'd be surprised to hear that I share a lot of the premises of your question. First of all, I'm not sure that we can entirely separate law from politics. I don't. So that's not problematic proposition for me. For instance, to give you one example, again, we're going to have a conversation. If I miss anything, come back and tell me you missed something here. Oftentimes you hear in the work of the ICC, for instance, oh, politics, or the ICJ, politics. But take the ICC, for example. The kinds of conduct we're dealing with are almost always necessarily political in their origins. I presided over one stark example will be the case, the trial of the current president of Kenya, who was at the time the vice president. It arose from post-election violence in Kenya in 2007, 2008. That is politics on stilts. Post-election violence, necessarily political. But it need not be that political on stilts, as I said. You could have every question of genocide in Germany, in Rwanda, elsewhere. People are raising that question in Gaza as well. All these questions deal with the right of people to exist. That is necessarily political. Right? Do I have the right to be in this space? Is there room for the other person to be in the same space? That is political. And so law, in my view, I think it's a pipe dream to say, well, we're going to have a law that's basically constructed it's never affected that politics. The problem is that the question rather is, are we going to run away from solving a legal problem because we can find some political connection somewhere there? And that, in my view, doesn't work. So what are the other things you asked again? Sorry.
Second part was, how do you see this right being more successful?
Yes.
Than a lot of other rights?
Again, very, very important question there. I think it's about tweaking a system. You have something and it becomes evident that what we have isn't working well enough. And it is for us to say, okay, it's not working well enough. What else can we do to make it work better? In some instances, it might be, well, maybe there's some glitch in what exists. Maybe if we remove that glitch, things can work better. For instance, the Rome Statutes implementation of the crime of aggression. I gave you one glitch it has. We extend, but there's another more fundamental one than that that exists, and that is denying the ICC jurisdiction over the crime of aggression, right? Committed on the territory of a state party to the Rome Statute by a state or nationals of a state that are not parties to the Rome Statute. So ICC cannot exercise that kind of jurisdiction because except when the Security Council authorizes it. And that's why when Ukraine was invaded by Russia, the ICC cannot prosecute the crime of aggression. You don't have that limitation in relation to genocide, war crimes, crimes against humanity. ICC could. ICC, issued an arrest warrant against Mr. Putin for war crimes, crimes against humanity, but not the crime of aggression because of that limitation. So there is a glitch there. And the correction there would be to remove that glitch, say, equalize the crime of aggression with genocide, crimes against humanity, war crimes, to make everything the same. So that's one thing that can be done to correct when we're working a system, see there's something in it that's not making it work as effectively as we want. We do something, could be adjustment that requires removing something. It could be an adjustment that requires adding something more to cover a space that could use being covered. And this is where the idea of the right to peace comes in, because it is something else that has not been tried, and it's greater efficacy than the other rights. You say, how are we sure that this may be better enforced than the other rights? It's because we don't have what I'm proposing now for the other rights, which is enforcement of that right using the national system. If you use the national system to enforce the right to peace, in the sense of saying anyone who invades another country, the victims of that invasion can sue the state or the leaders of the state or companies that are complicit in that. If you have that method, that, should I call it, democratization of accountability, give every state the right to the national court to judge that, it becomes more hazardous for states that want to engage in the crime of aggression, because they're no longer thinking about, look, it's me against the ICC prosecutor. If I can browbeat the ICC prosecutor, maybe I could get away with it. But if they have to think, well, the victims of this crime, of my conduct, can go to, let's say, if the US is a member state of this treaty, can come to the United States, come to University of Ireland, I don't know whether you have a law clinic here, get some professors to commence proceedings in the federal court of the US. The same thing in Switzerland, in Germany, and other places. It changes the calculation. You ask yourself, well, do I want to have to run around defending myself against different national systems where I may be sued, right? What is more? Now, there's a lot of investment, foreign investments by states in each other's jurisdictions. When the war in Ukraine broke out, the instinct of Western states seized the yachts of the oligarchs. Okay, and then they did that. Okay, you seize the yacht, you freeze the assets in bank accounts in your economies. Okay, now what? So I've seized the yacht, I've frozen the account. What do I do next? Well, international law does not allow you to just automatically take somebody's individual asset without a judicial process. They cannot politically seize the yacht, freeze somebody's bank account because, quote unquote, they are members of an oligarch, and expropriate them. You need a judicial inquiry to do that. Now, this is where this Right to Peace project comes in, because it gives you a basis upon which you can make that inquiry to decide whether or not you are going to freeze the asset and actually use it and totally expropriate it from the original owner. So it will be, in my view, one method that holds promise of being more efficacious than what we already have. Again, a very good question. I don't believe that I need to park it in any philosophical premise beyond the need to protect humanity from certain violent conduct, certain aspects of man's inhumanity to man. You can, of course, yes, Immanuel Kant did talk about his humane approach to the international order, where you violate the rights of somebody in one place, it affects the rights of somebody else elsewhere. So that can validate it. But we find that in the construct of international law, be it the Convention Against Genocide, be it the code of international humanitarian law is about the elementary considerations of humanity that have driven those concepts. How do we protect the dignity of the human person? So that is enough, in my view, of a philosophical premise for the norm. The elementary considerations of humanity that are as exacting in peacetime as in war. Okay, that we will need to, if we, not everyone will believe in a religious foundation for law, but it's enough if you construct a law in which some people will feel that it appeases to their religious, perspectives and all that. But it's important for us to think, how do we protect or enhance the protection of the dignity of the human person?
So at one point, you mentioned that some people would like to think of peace as including justice, economic well-being, so on. But I understood you to argue for a more minimalist understanding on the grounds that that would be easier to get buy-in for. But if peace is simply the absence of various other evils, aggression, and other crimes, I guess I wonder what it adds to what already can be said in terms of what's already illegal in the international scheme. So I just wonder if you could elaborate a little bit on your understanding of what peace consists in. Is it a substantive or simply the absence of other kinds of conditions, situations that get in the way of the exercise of rights?
Right. To summarize, the question is whether I think peace is a positive attribute or a negative one. Do I get it right? And what can it add to what's already there? Is it a substantive, again, something or other? Certainly peace is a positive attribute. Yes, when I say let's constrain it to begin with, it doesn't mean excluding other things that can come within the outer parameters of what we can accept to be peaceful in terms of the absence of something else that contradicts what is that. So it's purely a function of let's begin small, manageably, get what we can, and then what we can that everyone sees the value of, even that minimalist approach to begin with. And in future, if there's a need and agreement to expand it, we'll discuss it at that time. Now, is it something tangible versus the other right? I do not see that the right to peace, as that is not yet recognized as such in treaty, is less tangible to freedom of conscience, for instance. What does that mean? Right, everybody has, or freedom from freedom of expression. Freedom of expression is, you can say, but the right to peace, in my view, is just as tangible in the sense that when it is violated, you know it. It has drastic consequences that affect human life, that affect the right to security of the person in very dramatic ways, that affect the right to gain meaningful employment. People from Ukraine can tell you that as a child in Nigeria at age 3, there was a war, civil war in Nigeria. Many people in the room would have read or known about the Biafran civil war. As a child, I felt it, right? I knew what it was to, for instance, fear when you hear aviation noise, an airplane flying above. Because the airplane will fly above, and then 5 minutes later or so, there'll be a lower, more aggressive flyby, and bombs are dropped. And after the war, that war, for a long time, they hearing the noise of airplane flying over was a sign of danger. You sought cover. You didn't wear bright clothes because you may be spotted. So that would be the tangible qualities of the right to peace.
We've got a question from the online audience. In fact, you get some greetings from Alaska. I have a fairly simple question. As a previous judge in the ICC and continuing on to the Caribbean Court, what is it that keeps you humble, neutral, and accountable in your proceedings and rulings? And do most other international court judges have the same mindset? I guess maybe disposition to you.
Well, I cannot speak for any other person or most other person, but what keeps me humble is this. I was approached life, especially my work as a lawyer, as a judge, that for anything you see here and you think you've nailed down and understood here, there's a lot of stuff out there you don't see and you don't understand. Okay, so that has been, and that approach to it, to life and my work was always there, even before I watched the Conclave. Did anybody watch the Conclave? Right. You do remember the sermon of certainty, right? Where the cardinal say the greatest sin of all is the sin of certainty, to think you know it all, you've nailed it, and we pray for a pope who doubts. So there's a lot of doubting that goes on every day, all the time in my mind.
So thank you so much for your presentation. I'm a scholar of religion, so I'm a religious ethicist who's a genocide scholar. So of course, just like, I see dead people everywhere from the Sixth Sense, like I see religion everywhere. And so I really appreciate Hava's and Richard's questions, and I had something similar prepared. So I'm actually going to ask a different question. So with Hava's question, of course, she was talking about potential religious grounding for these rights. And I couldn't help but think of an overlapping consensus, like a Rawlsian kind of sense of we can agree this is a good thing, but we may not agree on the underpinnings for this particular position, right? So I also had a similar question. And then Richard mentioned the idea of peace. And the US Catholic bishops in 1983, right, with the challenge of peace, talked about the difference between negative peace and positive peace, right? This idea of just the absence of conflict versus actually promoting something for, peaceful flourishing. So both of you took my questions. So here's my third question. You aptly opened with the Peace of Westphalia, 1648. And as we know, that was considered a religious, war. And so my quick question is, when we talk about something like a right to peace and we want to enshroud it in international law as an international instrument, but as you mentioned, it often requires domestication. It often requires some kind of state. And so as we know, with the Peace of Westphalia, which really established this idea of sovereignty, we also have challenges to the concept of sovereignty since then, right? So with the UDHR, the Universal Declaration of Human Rights, the idea that regardless of your borders or certain rights that you are entitled to, the responsibility to protect did the same thing, right? So we have these challenges of sovereignty. So my question is, when we, in an age where the idea of sovereignty is changing and borders are kind of changing, and we also have an influx, or I shouldn't say an influx, but we see more and more people who are stateless, right? So either because they're refugees, because of climate, or because of warfare, because of genocide. I'm wondering how your particular idea of a right to peace might maybe be superior to or offer alternatives to how we ordinarily think of people who are stateless. In the sense of right now, we have the UNHCR, which I suppose under international law protects those who are stateless. But again, if most of those norms are being enforced through a state actor, or through a state entity, then there's a challenge to that. So my question is, does your right to peace, provide maybe a superior way of thinking about how we might protect people who are stateless? And then B, because international law also typically applies to states and not to individuals, as a religion scholar, I'm increasingly seeing more religious actors and institutions involved in issues of like diplomacy, or involved in issues of trying to provide services or reconciliation when state actors aren't involved. I'm wondering if your right to peace also can accommodate these non-state actors who typically are not subject to international law, right? How your particular model might help with those two things. I apologize. Is that too complicated a question? Okay, thank you.
Thank you. First of all, with the right to peace accommodate stateless persons, it all depends. Remember, I said it's important to constrain it to begin with and not expand it too much, because once you start expanding it, people, states go, we're not sure yet we want to do this. So starting small, and I want to insist on beginning with wars of aggression. So where the conditions or statelessness, you can link it to a war of aggression, sure. But if not, I would say let's wait and first of all establish the aggression base for the right to peace before extending it. Okay. Sovereignty. Sovereignty, as you know, rightly pointed out, is a problematic concept in international. And I do believe that a lot of, should we say, iterations, expressions, or takes, as it were, on sovereignty might have resulted from a distorted understanding of what sovereignty was all about to begin, even in the Treaty of Westphalia. Westphalia did not contemplate sovereignty in the sense of something that troubles international order. Sovereignty is about the who has the authority to decide what happens in the national order. When Jean Baudet came up with the idea of sovereignty shortly before the Peace of Westphalia, he was concerned, I think 1473 or so, he wrote his book, Six Livres de la République, or 6 Books of the Commonwealth. His concern was not about international relations. He wrote his book at a time when France was gripped by sectarian violence in France, at a time when you did not have a strong central authority in France. You had feudal lords, fiefdoms, and the feudal lords were the ones who really decided whether or not to support the king That's why Versailles was built, because the King of France, Louis XIV, felt he did not feel safe in Paris. So he wanted to move away. He had all these, lords and nobles running amok. So anyway, the point was that Baudet's concern was that we cannot have different feudal lords confusing the system with their own authority. It was important to have within France a central authority that directed the affairs of the state. And that central authority needed to be the King of France. That was Baudet's thesis about sovereignty. And he was careful to say that the sovereign of France, by the way, was bound to respect the law of nations, treaties with other states and the law of nations. So he was clear about that. But over time, people started conceiving of sovereignty in the sense of, well, yes, state A can do whatever state A wants and whatever state A wants to do to state B, and you cannot hold state A accountable because of sovereignty. That is a distorted understanding of sovereignty. You cannot have an international order in which you don't give up something in order to have a community. So that is the problem. Now, I think I heard you mention whether international law would also apply to non-state actors, since international law is understood to regulate relations between states. Was that? All right. Now, that understanding of international law changed effectively at the end of 1945, when it was recognized that before then, the sense was that international nation there, state law that regulated relations between states, that the individuals or entities within state did not have, were not subjects of international law. But that changed after the Second World War, where it became clear, and the Nuremberg Tribunal, for instance, made it clear that the international law could impose obligations on individuals, right, despite the obligations of the state itself on the international plane. The international law could impose obligations on individuals. That's why you had the Nuremberg trials, trying individuals, imposing individual criminal responsibility. That argument was made that the court rejected it, that no, you cannot absolve yourself from accountability because you believe you're acting on behalf of the state. Therefore, if you have any issue, what I've done, take it up with the state. No, Nuremberg Tribunal said, we'll take it up with the state at that level, but we'll also take it up with you at the individual level. So that changed. And then after the Second World War as well, we had the Human Rights, Declaration of Human Rights, the Universal Declaration of Human Rights, as well as international law of human rights, that has since recognized the right of individual as a concern of the international community or the international law. Now, even in national and corporations, legal entities, as it were, there are some treaties, international treaties, that actually impose obligations on legal entities in the sense of corporations and so on, conventions for the suppression of terrorism, the suppression of human trafficking and so on, or recognize that the corporation within a state can impose with international obligations as well. So yes, this treaty I'm thinking about will do the same thing, impose obligations on not only states, but also individuals and corporations who violate the right to peace. Okay, yeah, exactly. I think there's another question here.
Okay, yes. It's not a question. I find your treatise on the right to peace very intriguing. And the reason I'm standing up and finding it intriguing is, what is the likelihood of two little boys in rural Africa who were scared to death about the sound of airplanes dropping bombs around them, and also attending the same secondary school? Oh, you want me to go over there? All right. I said I find your treatise on the right to the Convention on Peace intriguing. So I'm not going to ask a question, but what's the likelihood of two little boys who were terrified about the sound of airplanes dropping bombs around them, and then eventually attending the same secondary school in a rural part of Africa, Nigeria, southeastern Nigeria, ending up in a venue like this, one a judge of international repute, and the other a professor of political science at Arizona State University. Chile and I were schoolmates. He was 2 years behind me at our secondary school, at our alma mater, St. Thomas Aquinas Secondary School, Mbano in Imo State, Nigeria. So I want us to take his positions very seriously, because peace, right to peace, or the Convention on Peace could be something that will begin to change the way we do business in international relations. It also incorporates the role or responsibilities of non-state actors, because he and I were also saved by a non-state actor that is involved in complex military operations or stability operations. The founding of Maison Sans Frontières was because of him and I. The two doctors that founded Médecins Sans Frontières were frustrated with international legal obligations of ICRC. The Red Cross had to get permission from the Nigerian government to break the blockade of food, using food as a weapon of war. We would have died, we could have died. So they broke away and said they could not stomach the genocide that was going on, and formed a separate organization called Doctors Without Borders. So thank you for putting your hand on a subject that should be of interest to everyone.
Thank you very much, Professor.
My name is Oke Iheduru. I'm a professor in political science here at ASU. So, and I haven't seen him or run into him since I graduated 2 years ahead of him, 78, him 1980. So,
High school. Thank you very much, Prof.
I have a general question about what I'm really concerned by. Oh, sorry. Can you hear me now? I'm very concerned about what's happening now, and I want to speak about politics. We've talked about how law can't be distanced, can't be disconnected from politics.
Cannot.
Yes, it can't. So my question is, when the main difference between the ICC and the ICJ is known to many, but I'll just reiterate the main points. ICJ is all about the issues that states have with one another, which is why South Africa resorted to the ICJ when it came to Gaza, or the Gambia as well resorted to the ICJ when it came to upholding the rights of the Rohingyas. The ICC is known to be, and whether this is factual or a rumor, you have to correct me, please, but the ICC has always been seen as having more of a US bias compared to the ICJ. That's what I remember learning as I studied international law.
So the US bias, positive or
Positively.
negative?
Positively
In other words, complying with US
Yes.
Okay, where's it going?
Politicking basically with the US along the lines of US's interests. Now, I see the trickle down effects of the current administration's attitude, approach towards the ICC. I see it among my students who, whenever I speak about anything to do with the laws there seems to be a lot of criticism, geared towards the ICC. My question is, how is the position of the current administration now going forward, you think, going to affect, how will it affect, how the ICC survives or continues to operate? Because if the ICC, if we're looking up to this institution in terms of upholding all these many rights we're talking about, and rightly so. And I think I also understand back then, being one of the scholars studying about, the right to information, how that, when it was implemented as a general right, it was so difficult to implement. But many scholars and many practitioners got together to, to basically make it happen by hook or by crook. And there were many obstacles. So I understand that the right to peace would have the same, there would be the same encumbrances, basically. But right now, I am concerned with the future of the ICC. And I'd love to hear your views, because you were the 4th president of the ICC.
And again, that anxiety is perfectly understandable, very, very reasonable. But I do believe that it is for all of us to decide what we want of the ICC. There is power in the individual. Oftentimes, we think that it is only those who lead our states, that have the prerogative to decide what they do in our name. But oftentimes, if we take it upon ourselves to make what we want known to those who lead us, they eventually do listen, especially in democracies. I was recently asked, what are the ways individuals can make themselves heard? Is by those in a position to express themselves to do so. The academics in this room belong in that class of people who are in a position to say what they think should be the direction of the states that they belong to. So they're not deprived of a voice. It's about them and their ability to, speak up and face down the glowerings that often would happen when you say something somebody doesn't want to hear. So academics can deploy the power of their voices to be heard individually. Another way, and this question came up not long ago somewhere, I forget where. Yes, I remember where it was. Somebody asked me, I was at Cambridge, at Harvard University 3-4 days ago. I was interviewed. And the question was about the role of the civil society, non-governmental organizations in the affairs of the ICC, international organizations. And I said that the civil society, the role of civil society is often unsung. People do not acknowledge civil society as much as they should. We're used to hearing the three estates and then the fourth estate, the press, but nobody has accounted for the estate of civil society. They are a very, very powerful agency for good behavior. They can also be agency like everything else of bad behavior. Some press people can confuse. You can have civil society that also engage in confusing behavior. But when it's done right, the civil society can channel the voice of the voiceless into national policy, even into international policy. A civil society were heavily instrumental in the creation of the ICC right after the what eventually became the ICC, right after the even First World War. They started mobilizing to encourage the International Parliamentary Union and all that, right? They were mobilizing in that direction. And when it came the American Bar Association's civil society, GO, very strong in insisting we want an ICC, and they've been very vocal against the attacks that their government often would deploy against the ICC. Okay, faith-based organizations have done the same thing. When the ICC was being created, even after the creation of the ICC, there was a coalition called the Coalition for the International Criminal Court, CICC. They still exist. So they were instrumental in mobilizing the ratification of the Rome Statute. They were just, even they're still doing that work. So they were organized within a state. You had the CICC, had chapters in various states. So they were organized to intercede with their government, put pressure, if you were. Remember, there was a time when civil society used to be called what? Pressure groups. Okay, so there was a reason for that. So they would put pressure on their government to do the right thing, and oftentimes they would. And also domestication of the Rome Statute. So civil society is a powerful force, can be a powerful force for good, and it can be a way of both those in any society who have the voice, as well as those who don't feel confident to stand alone on their own, can be able to channel their voices through civil society. So there are different ways in which we can decide whether we want to support the ICC or not. The difficulty is if we feel that that is an institution that has value, which we should support, and we don't. That is why the difficulty comes in. We wait for somebody else to do it instead of us saying, what can we do? Wasn't it that famous expression by JFK, don't ask what your country can do for you. The same thing applies for the international order. Should we wait, or let's wait for the international order to make the world a better place for us? Or should we say, hang on, we are the international order. We do have a stake in that. We have an idea of what needs to happen. We either express those ideas individually, or we find a coalition of people with similar viewpoints. So let's channel action together. So there is a lot of power, untapped power in the individuals to resist all these things we fear that is eroding good behavior in international order. Yes. But it depends on first of all, if it's about what can be done, through the ICC or the ICJ or whatever international institution, first of all, we need to identify what is possible within the constating instrument of that international institution. We can't do everything using it. First, we pick it up. Okay, how is it constructed? What are the extent of its jurisdiction? What can it do and what can it not do? And we identify those, and in order to decide, what, whether or not to even begin to approach it. So that is the way to go about it. You cannot litigate dismantling of USAID at the ICC. You can't do that at the ICC. But it's for you to decide whether that's a question you want to ask your national court. Is that the right thing to do? And let the national court, somebody was telling me, looks like we believe too much in the lawyering, in the legal system. I do. To the extent that there are some things the legal system is set up to do, let's use it to try and find the answers that may be possible using those systems. So not, when I returned to Canada, and I gave this, was at an event, and I had to give an answer to a group, an answer that broke my heart, but I had to give it. That was a gathering of very important constituency in Canada. Something awful had happened to them historically. And they asked, can we go to the ICC? I told them, I feel your pain, but I'm sorry, this is not a case that you can take through the ICC. There is no scope for that kind of litigation at the ICC. So it is like that for a lot of other things. Yes.
Okay, thank you. This was so kind of hopeful, this idea that there's a right to peace, and it's kind of the idea of an expansion of rights. I guess it feels very discordant to the moment right now in the United States, where, over the past, since the 1960s, we've had a real restriction of rights and a kind of narrowing of what we think of a rights. Right, right now, the right to free speech and the right to due process and all these things we took as for granted are suddenly on the chopping block if you don't have the right legal status. And so I guess and I'm a practicing lawyer, so I see it, and I see the kind of rights of people becoming constricted, and I think it comes from a root of feeling like people aren't deserving of rights, and an increasing sentiment, maybe not by people like this in this room, but across the country, that an inability to kind of empathize and see that other people that aren't situated exactly like you are deserving of these rights. And I guess, is the United States an outlier? Is there hope in the global community that there's a bigger heart to be had that we don't? And is there hope for the expansion of rights, or are we in a time of darkness where we're really kind of restricting what we believe other human beings have a right to?
I do have hope for the expansion of right, and that's not at all to diminish the anxiety you express. It is there. I do have hope in the sense that you do find, just as you would have in any complex society, and the average nation is a complex society, it is too much to hope that everybody will be singing from the same hymn sheet at all times. It doesn't, we know it doesn't work that way. But there are, valleys and troughs along, peaks and valleys rather along the way in the order of human affairs. The wheel of fortune can turn as well. You can, due to changes at a certain court, have judgments that come up with saying Black Americans are not citizens deserving of protection in the United States. And you have one justice dissenting vigorously, boldly dissenting vigorously against that. And later on, you have another bench of that court overturn the previous judgment. It can do good or bad. It could positive Roe v. Wade. Some point somebody overturned it. That's not to say in future you wouldn't have a return to that. So it is a struggle of society that needs to happen. From my perspective, the difficulty is if those who see a value in certain direction of good give up because they feel overwhelmed. Oh, it's too much. So no, I said no. Personally, yes, go home, cry about what's happening, and I do cry sometimes myself, and then wake up, dry your eyes. Okay, we're gonna get back off that, remount that saddle, and keep going. Don't lose hope. So that is the only. In my view, there is no perfect solution, but that is the struggle of life that we must go through. So I don't believe in giving up. I do believe that you're knocked down, you get up. Professor Hedru told, here's another personal story. You can edit this out of the video. At that high school, he was 2 years, but he wouldn't have seen this. And I was one of the younger ones in class, and it was one of the smaller ones. So it was an all-boys school. And there was this bully who, I mean, in those days, you settled your little boys, your differences using, and this guy would knock me down. I get up and go after him again. So that at some point he gave up. So that's it, I'm done. so sometimes that's what we have to do in life to get, okay, that's it, I give up. Thank you.
Well, let's get participating in that. Well, thank you for such a fantastic keynote and anticipating the applause. And that was a great question to end everything on. I think that's something on a lot of people's minds. So yeah, on behalf of the board and organizers of Genocide Awareness Week, thank you for attending the keynote, whether you're online or here. Again, thank you to the Rosenbluth Family Charitable Foundation, and of course to the Zorian Institute for bringing Judge Eboe Osuji here. And thank you so much, sir.
Thank you very much, Tim, for wonderful conference that you've pulled off. And next time you invite me, I will not think twice. I'm inviting myself to your next one. I will not think.
Oh, you're welcome here.
Especially since I know that Professor Hedru is here as well.
Always nice to have fellow Canadians around too. So,
all right. Thank you very much.